Hi, I welcome you all for my second video lecture on course Professional Ethics in Engineering. I am Professor CMT Karthikeyan, working for Computer Science and Engineering Department, Government College of Engineering, Bribery. Today, we are going to have a continuation of the previous video lecture on topic responsibilities and rights. The first four topics that we have taken for discussion in the previous video lecture. For today's discussion, we are going to have confidentiality, conflicts of interest, occupational crime, professional rights, employee rights, intellectual property rights, and finally we are going to have discrimination. Confidentiality. Confidentiality is nothing but keeping some sensitive information of organization secret without revealing that secret information outside the organization. It is the responsibility of both employee and employers to compete effectively with the business rivals. For example, doctors and counselors must keep information on their patients confidential. Teachers must keep at least personal information about the students confidential. Both are very important. In the same way, the employees and the employers should keep their trade secrets very safe. Confidential information related terms. On the basis of possession, confidentiality is divided into two types. First one is an privileged confidentiality or privileged information. Second one is a proprietary information. Privileged information. On the rarest occasions, we can provide the information of any sensitive details based on the requirement from the higher officials. For example, if any of the information is needed by the police department, we should not hesitate to give at that point of time. Then second one is an proprietary information. It is nothing but it is the trade information owned by an organization. That is nothing but a proprietary information. Yeah. So as I already told you that proprietary information is the information owned by an organization. It can be the secret about the product they are manufacturing, or the process, what process they are following to develop that product. Those that kind of information can be termed as an proprietary information or trade information, or trade secrets also we can say. So a limited legal protection is available for this proprietary information by common law. So there is no stringent legal protection provided for trade secrets. Patents versus trade secrets. So patents differ from trade secrets because patents legally protect specific products from being manufactured and sold by the competitors without the express permission of patent holder. For example, if you want to make use of the ideas that have been already patented, means first we need to get the permission from the specific patent holder. Then only we can make his idea to develop a product in our company. So patent is registered, that is the lifetime for patent is 17 years in US, but it is not so with trade secrets, because trade secrets are not getting registered. So which information can be easily known by other organization, means trade secrets can be very easily known by competitors organizations. How they can know? So we are anyhow the employees or employee are not going to reveal the secret information owned by that organization, though the other competitive organizations will try to know it based on the product you are developing by doing the reverse engineering. Justification and limits. Upon what moral basis does the confidentiality obligation rest with its wide scope and obvious importance? The obligation of confidentiality can be justified at two levels. The first level is to appeal to three ordinary moral considerations: respect for autonomy, respect for promises, regard for public well-being. Which means that respect for autonomy. So, if your organization is giving your freedom, you are enjoying that freedom, you should not use it to leak the information owned by the organization. That is the respect for an autonomy. Respect for promises you have made while you are joining the company. There will be an agreement, or there will be the terms and conditions while you are joining for a duty. So you have to abide by the terms and conditions. So one of the conditions may be that you should not reveal the information, secret information owned by that organization. That is nothing but respect for promises. Regard for public well-being. So this is also very important. Second level is to appeal directly to the major ethical theories. So this level is to appeal or act according to the ethical theories. Rights ethicists justify employees' confidentiality duty by appealing to basic human rights. That is, no employer has a right to safeguard the employee to keep the information secret if that information is going to affect the public welfare. Obviously, at that time, the employee should behave like a whistleblower by spreading that sensitive information that is going to affect the public. Duty ethicists will emphasize the basic duties of both employers and employees to maintain the trust placed in them at the time committed themselves to an employment agreement. So what does this statement say? So as I already told you that while you are joining a particular duty, so you have to abide by the terms and conditions of the employer. So that is has been given by duty ethicist. So there are two ways of approaching this confidentiality. That is rule utilitarians and act utilitarians. Rule utilitarians will view the rules governing the confidentiality as justified to the extent that such rules produce the most good for the greatest number of people. If the rules is going to do most good for public living in and around your organization, then the employees will be going to abide by your rules. Act utilitarians will focus on what action is being made by the organization, what is count on the confidential information, whether that confidential information is going to be useful or not. It is decided based on the actions made by the organization. Changing jobs, that is, so as the name implies, no employer can stop any employee quitting their jobs and join for other organization. So here there is a big question mark for the confidential information owned by the particular organization. So there is a fear from the employee side that once the employee is quitting a job and joining another organization, he or she may reveal the secret information. Changing jobs by the employees still affect the trade secret or confidential information owned by a particular organization. How? Former employees will disclose these trade secrets to new employers, or they can sell it for a higher price, or they can give it to the business competitors of former employees. How one management or employer can stop this kind of unethical activity? There should be a close relationship between employer and employee with regard to confidentiality, so that it can be extended beyond the limited period of their employment. In most of the situation, professional engineers will prefer career advancement rather than having a longer tie-up with the same organization. Management policies. How management policies will be helpful in retaining their trade secrets or confidential information. One approach is to have contractual agreement between the employers and employees in that they can place special restrictions on employees in terms of geographical location and types of jobs that he or she is going to take in the near future. So geographical location means the employer can tell the employee that he or she can take up the new job within our country, not outside the country. In terms of type of job, the employer can tell the employee that if he or she is moving out of the organization, he or she can take a new profile of job. The second approach is to give a lump sum amount to an employee so that the sensitive information of the organization can be retained for longer period of time. Then third approach, or the most straightforward approach from the employer side, is to have tighter controls on secret information so that no one can have access onto it. Conflict of interest. Conflict of interest occurs when employee is having more than one professional interest. For example, when the employee tries to work for more than one company at the same time, then it is a conflict of interest. This conflict of interest will affect the employer directly, because the employee is going to spend a time in more than one company. Obviously, the performance of the employee is going to come down, which will directly affect the outcome of the organization. Conflicting interest. Conflicting interest is different from conflict of interest. Conflicting interest is nothing but having two or more desires that cannot all be satisfied simultaneously at a given circumstances. For example, if a student tries to attend 4 arrear exams in a particular semester, but he or she can be capable of preparing for 3 subjects, then he or she has to give up 1 subject in that particular semester. Gifts and bribes. We know that gifts are given for appreciation, whereas bribes are given for expecting some undue favor. Pre-arranged payments for the contract made by the contractors to the companies in exchange for contracts actually granted are called kickbacks. This is one form of bribe. Bribes are immoral activity that is not at all encouraged by any employer. According to ABAT, no professional engineer should involve in getting bribes and doing undue favor to the one who is giving the bribe. Now we'll see the difference between bribe and gift in terms of various parameters. First parameter is timing. If it is given before, it refers to bribe. If it is given after, it refers to gift. In terms of cost of item, the cost is going to be high in case of bribe. It is going to be low in case of gift. Quality of the product. The product is going to be poor in case of a bribe, whereas the quality is going to be good in case of a gift. Transparency. Bribe is made in secret, whereas gift is made in open. Motive. Expecting some undue favor in case of bribe, whereas thanking for favor in case of a gift. What are the consequences that particular organization will face in case if it is accepting the bribe? It will be losing the reputation, or if it is accepting the gift, no damage is going to affect. Interest in other companies. So that's what we have already told that about conflicting interest. Now the interest in more than one company has been given a new term called as an moonlighting. When a person or employee tries to work for more than one firm, then that is called as an moonlighting. In any situation, moonlighting is not at all encouraged because it is going to degrade the performance for a employer to whom he or she is working for. Insider information. So obviously the employee knows the entire process involving in developing a particular product. So if he knows that information, he or she can share with their family members or to their friends to start a new business, and he or she also tries to invest on that business. It is totally against the employer to whom he or she is working for. Occupational crime. As the name implies, the crime committed by the professionals is called occupational crime. It is otherwise known as white collar crime. Industrial espionage. Espionage is nothing but spying. The spying is being done by many of the industries against the competitor industries to know their trade secrets. It is happening in most of the computer manufacturing industries. For an instance, we can see the chip manufacturing company, why they are doing this espionage activity. The development of chips is extremely competitive and on fast track. Profit and loss can be made quicker. The crime detection and law enforcement are difficult and ineffective. The components involved are very small. Endangering lives or risking lives. So this is about the employers. The employer, when the employer tries to expose their employees in a risk condition, then employees going to sue their employees for getting the monetary compensation. So employers should be very careful in providing the safety working conditions for the employees. So in no way employers should try to risk their employees' lives. Bootlegging. Bootlegging is nothing but manufacturing, selling or transporting any product that is prohibited by law or by government. For example, selling liquor which is prohibited on Gandhiji's birthday. If you are selling on that day, then you are performing an bootlegging. Rights of engineers. Engineers have many rights like moral rights and professional rights. Especially in terms of professional rights, he or she is having all freedom to deny the job assigned by the superior when he or she feels that the job assigned is going to be unethical. Whistleblowing. Whistleblowing is nothing but alerting relevant persons to some moral or legal corruption. These are the features of whistleblowing. Act of disclosure. This is nothing but the information will be provided outside the organization through the organization channels itself. That is nothing but an act of disclosure. Topic. Some information which worries what person believes is a significant problem for the organization. That is called as a topic. Agent. Agent is nothing but the person disclosing the information, maybe an current working employee or a former employee. Recipient. The information is conveyed to a particular person or an organization to act on the problems. Types of whistleblowing. Based on the designation, whistleblowing is classified into internal and external whistleblowing. So, as the name implies, the information is transmitted within an organization, or otherwise the information which is going to be very sensitive or which is going to affect the organization, then employee who is working for that organization can transmit to the higher officials. That is called as an internal. If something or the information or some incident that is going to affect the public lives, then the employee can transmit that information outside the company. That is called as an external whistleblowing. Based on the source, whistleblowing is classified into open, anonymous, partly anonymous. Open means everyone knows that who has spread or who has transmitted this information. Anonymous means everyone knows the information but doesn't know who has spread that news. Partly anonymous, which means that some of them may know that who has spread that, and some of them may not know that who has spread this news. When to justify whistleblowing? These are the following situations that tells you or that justify whistleblowing. When the potential harm existing is identified as serious or anticipated to occur with a high probability in near future, whistleblowing is justifiable. The concerns have been reported earlier, or the issues involving in our company have been reported earlier to the higher officials. Still, we didn't get any response within the limited period of time. Then the whistleblowing is justifiable. Then third point is, there is a reasonable hope that whistleblowing can prevent the damage existing or anticipated. So, following instructions to be followed before whistleblowing. One should familiarize with the rules for appealing within an organization. First, the employee should be very familiar with the rules for appealing within an organization. Then, he or she has to consult with the trusted colleagues for advice and to avoid isolation. Then third one is, use polite and tactful language to his or her superiors. Keep the supervisors or superiors informed of our actions through informal discussion. Keep our observations and claims precise and accurate, and have a record of events in support of our victims. Employee rights. Employee rights are any rights, moral or legal, that involve the status of being an employee. Employee rights include fundamental human rights relevant to the employment situation. In any organization, no one should be discriminated on the basis of sex, religion, race, etc. So, every employee should have a right that he or she cannot be discriminated based on these factors. Right to privacy. So, every employee should have their own privacy. They should have a freedom to enjoy their private life outside the organization. But employees have some restrictions in special situations. So they can have access to the personal information of an employee in the rarest situations. For example, something unwanted or unexpected events happen, then the employees can have rights. In rarest of rare situation, only duly authorized persons can get the personal information. For example, a supervisor might suspect a worker and conduct a research in his cupboard when the worker is absent. But the supervisor is to have another officer as witness in those cases. Right to choose outside activities. This means the employee is having all rights to choose the activities outside the job. But there will be some restrictions from the employer's side when those activities lead to violation. When the employee is performing a moonlighting, I think we know that moonlighting means trying to perform or trying to work for more than one company, when the interest of the employer is getting damaged. Right to due process from employer. So this is the right given to the employer to take fair process or procedures in terms of disciplinary actions against the employee. So first, the written explanation should be asked from the employee. If the employer is satisfied with the written explanation, then there won't be any disciplinary action. Or otherwise, the employer has all rights to demote the employee, or he can remove the employee out of an organization. Fairness here is specified in terms of the process rather than the outcomes. Here, this right is should be carefully handled in such a way that it should not be bother about the outcome. It should be bother about the process involved in it. Now we are going to discuss about intellectual property rights. It is the information and original expression that derives its original value from creative ideas and is with a commercial value. Intellectual property rights permits people to have fully independent ownership for their innovations and creativity. This tells that without the permission of the intellectual property holder, no one can use the product or idea which has been implemented by the IP holder. Need for protection of IP. IP prevents others using the product that has been developed. It prevents using it for financial gain. It provides a strategy to generate steady income. How? Means if anyone wants to make use of the idea by the IP holder, then he can get the permission from him, so that he has to pay and get the idea and make use of it for developing a new product in their companies. It prevents plagiarism. No one can repeat or no one can rebuild the same product. Types and norms. Patents is one of the intellectual property rights. It's a contract between the individual and the society. Patents protect legally the specific product from sold by the others without the permission of patent holder. That's what I have told. If anyone wants to make use of the idea, we need to get the permission from the respective patent holder by paying some lump sum amount, then only we can use it. Types of patents. Utility patent, industrial design patent. Utility patent. So utility patent is given for the invention of a new product that is going to be useful for the society. Industrial design patent is a patent given to the design made by a particular industry. For example, we can take car industries. You can see that no car will be having the same design. At least there will be some moderate or smaller change in the design. Copyright. Copyright is specific or exclusive right describing rights given to the creators for the literary and artistic works. It is not given to an idea. Rather, it has been given to the creative works which gives aesthetic looks, music, paintings, etc. Copyright gives protection to particular expression. As I already told you, it is not given for the idea. So recently also we have heard about the news of copyrights raised by the musical maestro Ilayaraja. Trademark. Trademark is wide identity of specific goods and services, permitting differences to be made among different trades. For example, we can the trademarks will be coming in form of labels, logo, or tagline, something like that. You can see that every organization is having an own tagline or own logos. For example, we can take the two companies Honda and Hyundai. You can see how the trademark has been differentiated. The H has been differentiated in its own way to differentiate between the Hyundai car company and Honda car company. Trade secret. So as I already told you that trade secret is nothing but the secret or confidential information owned by an organization. It is not that much having that much protection as the protection given to patents and copyrights. So anyone can copy or anyone can get the trade secret, take trade secret to gain the business knowledge of their competitors. Discrimination. Discrimination is not morally justified. It should not be there in any organization for any employee. It is considered as an offensive action if it happens based on sex, religion, race, etc. Discrimination examples. A senior manager post is vacant. There is a competent and proven candidate from outside the state. A local engineer with lesser competence is proved. Prize amounts for the winners in the world sport are not the same for men and women. This itself gives a clear explanation for discrimination. Preferential treatment. Preferential treatment is nothing but giving undue rights to a particular person in an organization, which differentiates him or her among the other employees. It should not be there in any organization. Sexual harassment. It is particularly offensive it's a particularly offensive form of sex discrimination. It involving, as it doesn't only the abuse of gender roles and work-related power relationship, but the abuse of sexual intimacy itself. It may come in many forms: sexual threats, sexual offer, sexual assaults, sexual annoyance. So example, one can offer a job if he is expecting some sexual favor from the person who is going to be offered with the job. So these are all the textbook and reference books that I have followed for this presentation. These are all the review questions that can be useful for the exams. Thank you for your patient listening.